Melinda Gates is a billionaire and one of the world's most powerful women, according to Forbes, but she lost a UDRP complaint for the domain name melindagates.com. And in this video, I'll explain why she lost and what lessons other trademark owners, women, men, and companies of every size can learn from this case. So Gates, as you may know, is co-chair of the Bill and Melinda Gates Foundation, the organization that she leads with her former husband and Microsoft co-founder, Bill Gates. Forbes calls her one of the most powerful women in philanthropy and estimates her net worth at more than $6 billion. One of the top results in a Google search for her name leads to a profile page on the Gates Foundation website. And although she is apparently the registrant of the domain name melindagates.org, which she won in a UDRP decision in 2017, that domain name is not associated with an active website. Now, I don't know what motivated Melinda Gates to file a UDRP complaint for melindagates.com now in 2022, 5 years after she won the .org variation and 23 years after the domain name was created in 1999. But she has been in the news, perhaps a bit more, since her divorce from Bill Gates last year. For example, about 5 months before filing her UDRP complaint, the Wall Street Journal reported that she was no longer pledging to give the bulk of her wealth to the Bill and Melinda Gates Foundation, and instead planned to spread it among philanthropic endeavors. So whatever her reason was for filing the UDRP complaint now, Gates obviously did not have the same success with the .com version of her name that she had with the .org version 5 years ago. But the different outcome has nothing to do with the top-level domain itself, .com versus .org, but instead with timing and trademark rights. Here's what I mean. Melinda Gates lost her UDRP case because of a combination of two factors. First, she only claimed common law trademark rights in her name, which is acceptable under the UDRP since a trademark registration is not required. But second, she failed to establish that those rights existed in 1999 when the disputed domain name was registered. And as a result, the panel said that Gates could not prevail on the third element of the UDRP, which requires proof that the domain name has been registered and is being used in bad faith. Now, this language is very important, especially use of the word "and", because it means that a complainant must show that bad faith existed at the time of the domain name registration, as well as now. But according to the UDRP decision here, Melinda Gates claimed that she only began using her name as a trademark in 1997, which means, as the panel wrote, this leaves a window of less than 2.5 years during which complainant must have developed the name Melinda Gates into a distinctive mark under the common law, because it cannot be said that respondent registered the domain name in bad faith before complainant's personal name had ripened into a protectable mark. Now, unfortunately for Melinda Gates, the only evidence of trademark usage that her lawyers apparently provided was what the panel called information about a handful of events in connection with which she was featured in published reports for her charitable giving during that crucial time period. And while the panel acknowledged that Gates has since become well known for her charitable work, it said, "Our analysis here must be confined to events and circumstances in the time frame preceding registration of the contested domain name." And as a result, the panel concluded that Gates has not proven that her personal name had ripened into a protectable common law mark by the time respondent registered the melindagates.com domain name. Complainant has thus failed to show that respondent registered the domain name in bad faith when that occurred in May of 1999. Now, this outcome differs from the melindagates.org case I mentioned earlier, in which Melinda Gates received a winning decision ordering transfer of the domain name to her. And that's because in the earlier case, the disputed domain name was actually registered much later in 2011, according to the panel in the current case. Now, as an aside, I find it curious that the earlier decision actually doesn't refer to that 2011 date. But the current 3-member panel includes one panelist who also participated in the earlier case, and the new decision cites the WHOIS database. In any event, the current panel defended its decision by writing that despite the different outcomes, the two cases are consistent on the facts. Now, it's impossible to know whether Gates lost this newest case because her attorneys failed to include appropriate evidence of her common law trademark rights during the relevant time period, or whether such evidence simply just doesn't exist. Whatever the case, it's a shame because the decision says that the respondent in the case has a history of cyber squatting. But as the decision notes, Melinda Gates can still file suit in court over the domain name, though there's no guarantee she would be successful there either. Now, I suppose the biggest lesson from this case for other would-be complainants in UDRP cases, whether individuals or businesses, is to fully appreciate and understand the UDRP's requirements before filing a complaint. Previous success does not guarantee the same results. And just because a complainant is famous does not guarantee a winning decision. Indeed, cases involving personal names and common law trademark rights are often challenging, especially where the disputed domain name is relatively old. Plenty of others have learned this lesson too, with many well-known individuals losing UDRP disputes. And interestingly, for whatever it may be worth, I couldn't help but notice that Bill Gates is not the registrant of billgates.com, a domain name that contains a notice that says it may be for sale. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.